All right, this is Diesel We the People News. I believe I've seen this and done a little bit of a video on Kirk's Law Corner News, and but to be honest, I can't remember, and I'm a little bit on the sleepy side. But I thought this was very, very important as I was laying in bed, just kind of going through videos. Right. Um, Number one, I'm Diesel We the People News. And this is educational purposes only. I'm not an attorney. I'm not giving legal advice. I'm hearsay. This video's hearsay. So go ahead and never look straight forward and always look around you to be able to protect yourself by any means necessary. Use the Second Amendment, arm yourself with knowledge. That's the reason why they described a particular type of arm with, the bang bang. Okay? They're doing a particular type of arms. But there are several different type of arms, people. All right? And the grand jury is supposed to be unanimous, right? It's better to set 100 guilty people free than it is for one innocent man to spend any time in prison or jail, technically. All right? And there's a due process in there. And they're obligated. The judges are obligated. The prosecutor's obligated, right? To get the jury in there and to get that unanimous ruling. All right? The grand jury is supposed to judge the facts and the law. And we've been giving these judges and prosecutors too much power. All right? And I don't know too much about this guy. I know that I believe when I did a video previous a while back that I liked him, if it's the same one. But it doesn't change the fact on this video, he is speaking truth. Okay? And I'm probably going to look at some more videos later on. But let's check out what he had to say. And what in the hell am I talking about?
There is a maximum law that says that you can't be punished for having rights. You can't be punished for having rights. And so, if you have the right to an indictment by a grand jury because someone has an obligation to ensure that you have, or someone has an obligation to...
Listen to that. Obligation, right? They signed an oath of office. They're obligated. They're our servant. They're supposed to be doing due process. And we have an opportunity to face our accuser. Okay?
To make sure that you have a jury trial, as codified in Amendment 6, as codified in Article 3. If you have the right to a trial by jury, that's your right because someone else has the obligation to do it. So, when they say to you, when a prosecutor says to you, well, you know what, if you plead guilty right now, and if you don't come and testify, and you don't defend yourself, and you don't make us have to actually, deliver on the obligations that we have, then we'll let you go right now. We'll if you sign a plea bargain, we'll let you go, you're free. But if you exercise your rights to defend yourself and make us actually have to do what we're already constitutionally obligated to do, you're going to get punished even more. And so the problem there is that you're absolutely 100% being punished for having a right, because that's what happens. With a plea bargain, they say, oh, well, if you don't come and testify, if you don't defend yourself, if you just say that you're guilty, regardless of whether you're guilty or not, if you do so, we'll let you go, or we'll reduce it, or we won't, have these charges. But if you choose to exercise your rights and defend yourself and make us have to do what we're actually constituted and obligated to do, we're going to punish you even more. We're going to add charges, or we're going to add time, or we're going to sentence you to the maximum amount. And that is absolutely 100% being punished for having a right. And you can never, ever be punished for having a right. They can't punish you for having a duty. You have to look at the necessary evil. Is it...
I'm going to pause there. How many times have you guys heard, right? You're pro se, and they're telling you you're fully responsible. But if you get an attorney, your attorney's not fully responsible, and you can sign a defective counsel. And I challenge even the counsel part, right? You're not supposed to have an attorney. You're supposed to have counsel, right? He's to kind of lead you through the weeds, but you still are to speak to the courts. That is the true due process in this country, okay? We're not supposed to just call up attorney and have him, you know, uh, do beg for us, all right?
Better to say this so that I don't have to serve the rest of my life in prison, and I actually have an opportunity to get out. Well, he made a decision, and it's the same decision that millions of people across country do every single day. What happened to the nation that Benjamin Franklin spoke of when he said that it's better that 1,000 guilty go free than for one innocent man being made to suffer? That's not what we have in place today. We have a shift in the burden of proof. We have a shift in the presumption of guilt. And no one's presumed to be innocent because you're immediately arrested without even having the opportunity to confront the accusations against you. You're treated as though you're guilty. You're locked up and forced into an institution because someone else said that you did something, and you've never had the opportunity to be able to confront those.
Okay, so I don't know about the 1,000, okay? Benjamin Franklin, I believe he said 100, so he may be a little bit incorrect and offbeat on that. But, excuse me, it's the result is still the same, all right? And it was supposed to be hard for them to convict you, okay? We're not supposed to have Terry versus Ohio, all right? That's a violation of the Fourth Amendment and the Fifth Amendment, okay? Well, for officer safety, he had a bang bang in his car. Well, again, that's a violation of the Sixth Amendment. Oh, shut up. Well, that's the violation of the First Amendment, right? And and then like the Fifth Circuit, you know, uh, you got to invoke every single time. No. That's not the way it's supposed to work.
Accusations against you, and at the end of the day, they don't want you to tell your side of the story, which is absolutely witness tampering, intimidation, coercion, and duress. There's witnesses on both sides. There's witnesses on the defense. There's witnesses on the prosecution, and all witnesses are protected from interference and tampering, intimidation, duress. So if you were to call up the prosecutor's witness, the accuser, and say to them, "Well, I'll shoot you if you come and testify," you'd go to prison for that. So how is that any different than the prosecutor coming to you directly or indirectly and saying, "Well, if you come and testify, I'm going to send you to prison for 20 years"? You see, what they're doing is they're using an abuse of their powers in order to get you to do what they want through an abuse of through duress, coercion, and intimidation. That is a crime.
And the judges do that with the pro se's all the time. Well, you can be looking at 20 years, 10 years, right? And they will do it with the pro se's. Okay? They cannot have little people rise up, be educated, and then they actually have to cover their dirty deeds, okay? Their unclean hands. And hoping by trickery of words, you get lost and confused, and you get sentenced, and the judge and the prosecutor sit there and laugh at you.
It's witness tampering, intimidation. Again, every single witness is protected. They're protected from these acts. And part of my argument from the very beginning, and you guys got to understand that I am an expert in terrorism. I'm an expert in it. That's one of the specialties that I did in my forensics degree. And that's what I did when I was with intelligence. That's what I did when I was with Department of Energy. That's what I did when I was with my company. I dealt with terrorism. And terrorism is quite simply defined as this the threat or use of threat in order to bring about a desired result from one organization to another organization. So when you
All right, look at that organization to another organization. Okay, now granted, prosecutor is a bar member with the judge being a bar member, but on the side note, A judge is supposed to be judicial. Prosecutor is just supposed to be an attorney. And then you get the officer comes in, which is the different a magistrate or administrative branch, right? There are all different uh, uh, administrative branches, and they're working together against you, which is conflict of interest. So the court system, as of today, is in conflict of interest against you.
Use threats or intimidation to bring about a desired result from one group to another group, that is an act of terrorism. And so we have, this understanding, something we've come quite accustomed to here in America. After 9/11 and the knee-jerk overreactions that we had from 9/11, we've come to understand terrorism because it's been brought into our own borders and affected our own citizens in such a dramatic way by our own government. And so, we got to understand that terrorism is not right. Terrorism can be emotional terrorism. Terrorism can be deprivation tactics that are designed to get you to comply with someone else's desired results. And that's exactly what happened.
So when you get pulled over by the cops, the first thing you do, what? Your heart starts beating really fast. You start getting nervous and all that kind of stuff. Well, then your heart starts beating really fast and you're getting really nervous because you're in court. Why? It's because the executive branch and the judicial branch is working together to scare you. And they don't even have to threaten you in any way. Just their presence scare you. When the government fears the people, then that's when we have true freedom. But if you are afraid of the government, then that's when you have true tyranny.
Every single day. But terrorism is a crime, and it's a pretty serious crime. And so when our own government brings the tactics that we employed in Guantanamo Bay and Camp X-Ray, and we employ those exact same deprivation tactics in every single jail and prison across the country in order to bring about a desired result, because we simply we want people to comply with the things that we say that they did, or the person that they say that they are. Well, unfortunately, that is a fucking crime. And it's disgusting at that, because the purpose of our government was not to oppress the people or to place them into a state of fear. And the purpose was to ensure happy life and through good government.
If it's become easier for the government to...
And I want to do a little stretch further, and this probably was shut off due to time running out. What was I going to say? Maybe it'll come back to me.
Find a crime, that's nothing compared to how easy it's...
When you're innocent and you go ahead and plead guilty just to have it done with, you just committed perjury. Okay? You just committed perjury. Then when the judge asks you, well, have you been, did they do this and this and this? Have you been coerced and all that kind of stuff? And when you say no, you committed perjury. That judge knows you committed perjury. He knows you've been coerced. Okay? And to be fair and honest, the reason why most judges say, well, I'm going to go ahead and plead for you of not guilty, is so you can actually have the due process. So they're kind of hinting these things out. But again, at the end of the day, that exact same judge is going to sentence you the whole 10 years because you go ahead and decide to fight your case.
Come to prosecute one. Bobby Unser and Aaron Swartz are rarities these days for declining plea deals. In recent years, about 97% of felony convictions at the federal level and 94% of felony convictions at the state level have come by way of plea agreements. It's yet one more relatively new development in our criminal justice system. In his article, Plea Bargaining and Its History, Professor Albert Alschuler traced the history of plea bargaining and concluded that it was essentially unknown during most of the history of the common law. In fact, for many centuries, Anglo-American courts did not encourage guilty pleas, but actively discouraged them. That started to change around the end of the 19th century, but once again, transformational change came only in the latter half of the 20th. As one scholar recounted in 2005, while the federal guilty plea rate stayed flat during some periods and even declined significantly during the 1950s and 1960s, it experienced a relentless climb from the early 1970s. This newly aggressive reliance on plea bargaining to adjudicate guilt represents a radical shift for a nation that professes to value trial by jury as the gold standard for testing culpability. The trial of all crimes, Article 3 of the Constitution says, except in cases of impeachment shall be by jury. Our founders valued the jury trial so highly that they repeated its guarantee in the Bill of Rights. In the Sixth Amendment, defendants are assured not just the right to a speedy and public trial by an impartial jury, but also certain rights during trial itself. Among them, the right to confront witnesses against them and to have the assistance of counsel for their defense. On the surface, our devotion to the trial may seem unshaken. We still venerate the great trial lawyer.
Even when they read your Mirandas, if you start listening to some of these videos about the Miranda warnings, right, you have a right to an attorney. You have a right to a lawyer. But anymore, very rarely do you ever hear you have a right to counsel. Why is that, people? Sit and think about it.
Of the past and consume vast quantities of television courtroom dramas. So how is it that the criminal trial has in short order become a feature more of fiction than fact? Surely this development has something to do with the changes to our criminal laws we have already discussed, including the growing number of criminal offenses, lowered mens rea standards, and the rise of ever more draconian penalties. Often, prosecutors can now pick from a smorgasbord of criminal offenses and heap on many overlapping charges, some with low or no mens rea requirements, all carrying their own potential penalties, sometimes including formidable mandatory minimum prison terms. Pause for a moment over Aaron's predicament. He faced the possibility.
Well, I'm running out of time. Think outside the box, people. This is where our due process is now. Threat and coercion from all these administrative agencies against you. These are We the People News. Bye, y'all.